Imagine doing something like entirely legal on a Monday. You just go about your day, you follow all the rules, and you go to sleep.
Right, just a totally normal day.
Exactly. But then, by Wednesday, the state changes the law, and they actually work backward in time and throw you in prison for what you did 2 days ago.
Which just sounds completely insane.
It sounds like a dystopian novel. I mean, it sounds impossible. But it is exactly the kind of scenario that criminal law is designed to prevent. And today, we are going to explore exactly how that works.
We are. It's a huge topic.
Yeah, we are diving into the ultimate test of these rules, which is the multi-state bar examination, or the MBE. Today's deep dive is laser-focused on one mission.
Helping you, the listener, pass this exam.
Exactly. We are taking a foundational primer on criminal law, tailored specifically for the MBE, and we're going to break it down.
And that is exactly our goal today, because criminal law at its core is really about power. It's about the immense power of the state to punish you.
Right, they have a lot of it.
They really do. The state can lock you in a cell. They can, take away your property. The state can even take your life. That is the ultimate authority.
Yeah, that's heavy.
It is. But the MBE does not just test your knowledge of that power. It actually tests your knowledge of the limits of that power. Like, it tests where the state absolutely must stop.
Okay, let's unpack this. Because
Yeah.
the MBE is notorious, right?
Yeah.
It's just full of tricks.
Oh, absolutely. The examiners want to see if you really grasp the concepts or if you are, just guessing.
Right. And because we know many of you are preparing for this massive exam, we're setting some ground rules for our conversation today. We want this deep dive to be the ultimate audio study guide.
Which means keeping it accessible.
Yes. So we are going to use very simple English. We will use simple grammar. We are going to avoid confusing legal jargon whenever we possibly can.
That's a great rule.
And if we have to use like a Latin term or a complex concept, we will break it down into plain words. We're also going to pause often to recap. We want to point out exactly what you need to keep in your notes.
I think that is a brilliant approach. I mean, the law is complicated enough, right? The language we use to explain it shouldn't be.
Exactly.
If we connect this to the bigger picture, mastering the MBE is really about building a simple, strong foundation. Because if your foundation is solid, no trick question can fool you. You'll just see right through the confusion.
I love that. So let's begin with the overarching strategy. Let's look at the MBE playbook.
The playbook is essential.
Right. I like the idea of a playbook. Before you memorize like 1,000 rules, you need to know how the game is actually played. So what is the default setting for the MBE?
That's the first major hurdle students face.
Like if a listener sits down, opens the test booklet, and reads a random criminal law question, what law are they actually applying?
Yeah.
Are they in New York, California?
They aren't in any specific state. The default rule is that you must apply the generally accepted view.
Wait, the generally accepted view.
Yes. The examiners will give you a scenario, and often they won't tell you which state you're in. They will just say, in a certain jurisdiction.
Oh, I see.
And because every state has slightly different laws, you can't rely on the specific quirks of your home state. You have to use the rule that the majority of states use. You apply that general view unless the test question specifically tells you to do something else.
Okay, so the general view is our baseline. But the examiners leave clues, right? How do we know when to actually deviate from that baseline?
You have to read the prompt like a detective looking for clues.
Like what specific words should a listener underline?
Well, the question might explicitly mention the common law. If you see those words, you immediately shift your brain. You apply the old rules created by judges.
Okay, common law. Got it.
Or the question might mention the MPC. That stands for the Model Penal Code. If you see MPC, you apply that very specific set of rules.
Right. What about regular laws?
Sometimes the prompt will give you a completely made-up statute. Like, it will quote the exact text of a fake law. If they give you a statute, your only job is to apply the words of that statute.
Just literally what's on the page.
Exactly. And finally, look out for famous legal names. The prompt might mention the Wharton rule for conspiracy, or the M-not-in test for insanity. If they drop a name like that, they are testing your knowledge of that specific famous doctrine.
That makes a lot of sense. We follow the majority rule unless we see a flashing neon sign pointing to the Model Penal Code or the common law.
You've got it.
But wait, what if there are no signs? What if the prompt just describes a crime, like a guy breaking into a house and says absolutely nothing about the jurisdiction or the statute? I feel like that would cause a lot of panic.
What's fascinating here is that this exact scenario causes massive panic, and the examiners know it. We actually call this the missing elements trick.
A missing elements trick.
Yeah, students spend months memorizing the exact elements of burglary at common law versus burglary under modern statutes. Then they get a question that doesn't specify which version applies, and they just freeze.
Yeah, I would freeze too.
But you shouldn't panic.
Why not? I mean, if they don't tell us the rule, how do we find the answer?
Because if the examiners leave out that information, it means the specific elements of the crime do not matter for that particular question. It's actually a gift.
A gift.
Wait, really? Yes. They are telling you to ignore the tiny details.
Okay, I need an example to visualize this. Let's use the example from our source text about voluntary intoxication.
Perfect example. So, voluntary intoxication means choosing to drink alcohol or, take drugs until you are impaired.
Right.
Suppose the question describes a man who gets incredibly drunk at a bar. He then walks outside and commits a crime. The question asks, is his voluntary intoxication a valid defense to this crime?
Okay.
But the prompt does not tell you if the state uses the common law or a modern statute.
So the listener is sitting there thinking, wait, does this state allow intoxication as a defense to burglary? I don't know the exact statute.
Exactly. But they are missing the forest for the trees. For the defense of voluntary intoxication, the only thing that actually matters across all jurisdictions is the required mental state of the crime.
Oh, the mental state.
Right. Does the crime require a specific intent, meaning you had to act with a very specific goal in mind? Or does it require general intent, meaning you just intended to do the physical act?
Let me see if I follow this. So if it is a specific intent crime, being blackout drunk might prevent you from forming that specific goal in your brain.
Exactly.
You were just too drunk to plan anything. But if it is a general intent crime, being drunk is not an excuse. You still chose to swing your fist even if you were drunk.
That is perfectly stated, and that is the broad concept the examiners are testing. They want to know if you understand how intoxication interacts with mental states. They don't care if you know whether the crime occurred at night or if it involved a dwelling house or, any of the other tiny elements that change from state to state. If they don't give you the specific law, focus entirely on the broad fundamental concept.
Wow. That is a massive stress reliever. If they hide the ball, it means the ball doesn't matter. Look at the big picture.
Exactly. Keep it simple.
Let's pause right here for our first recap. Listeners, grab your pens. This is for your notes on the MBE playbook. Rule 1, always use the general majority view as your default.
Right.
Rule 2, scan the question carefully for clues. Circle words like common law or model penal code. And Rule 3, if there are no clues about the specific law, do not panic. The examiners are testing a broad concept, like mental state. Do not get bogged down in tiny elements if the prompt does not ask for them.
That is an excellent summary. You have to keep those rules in mind for every single question.
Okay, now that we have our test strategy, let's dive into the law itself.
Okay.
Because before a prosecutor can even charge you with a crime, the court has to have the power to hear the case.
That's step 1.
Right, like if a judge in Texas tries to put me in jail for speeding in Japan, that judge has no power over me. Which brings us to Section 2 jurisdiction. Who actually has the power to punish?
Jurisdiction is really the foundation of criminal law. It's the authority of a sovereign entity, like a state or a country, to create and enforce laws.
Without it, you have nothing.
Right. Without jurisdiction, a court is just a room full of people talking. The proceedings are legally meaningless. To understand jurisdiction for the MBE, we have to look at the two big players, the federal government and the state governments. And they operate under very different rules.
Okay, let's start with the federal government. The FBI, the federal courts, the federal prisons, they seem incredibly powerful. Do they just have power over everything, everywhere in the country?
It might seem that way on television, but legally, no. The federal government is actually a government of limited powers.
Limited powers.
Yeah. It does not have a general police power to just make up laws about everything. Its power to criminalize conduct falls into very specific, limited categories.
So what is the first category of federal power?
The first category is simple geography. The federal government has power where it actually owns the land.
Like federal property. Give me some examples.
Well, the District of Columbia is the biggest example. The federal government controls D.C. entirely. But they also own military bases, naval yards, and federal courthouses.
Right, okay.
They own a massive tracts of land out west, and they own all the national parks. If you commit an assault in Yellowstone National Park, the state of Wyoming might not handle it. The federal government has jurisdiction because it is their land. They make the rules on their property.
That makes perfect sense. My house, my rules. But what if I'm not in a national park? What if I am standing on a public street in downtown Chicago or, I don't know, sitting in my own living room in Ohio? Does the federal government have any power over me there?
Yes, but only if they have a specific constitutional excuse. The federal power to criminalize conduct within a state's borders is very limited. Every federal criminal statute must be founded upon a specific grant of authority found in the United States Constitution.
The Constitution actually has to give them permission.
Exactly.
How does it do that?
Well, this grant of authority can be expressed, meaning it's written directly in the text. For example, the Constitution explicitly gives Congress the power to punish counterfeiting.
Oh, like making fake money.
Right. So making fake money is a federal crime anywhere in the country. But the power can also be implied. The biggest implied power comes from the Commerce Clause. The Constitution says Congress can regulate interstate commerce, meaning business that crosses state lines.
So if I hijack a truck full of goods that is driving from New York to Pennsylvania, the federal government can step in because I'm messing with interstate commerce.
Precisely. Because the truck is moving between states, it falls under the Commerce Clause. The federal government uses this clause to justify a massive amount of criminal law.
Like what?
Wire fraud, transporting stolen goods across state lines, even certain drug offenses are often tied to the idea that the conduct affects interstate commerce. But the key takeaway for your notes is this: without a tie to the Constitution, the federal government has no power inside a state.
Okay, but what about outside the country? Does federal power just stop at the border? Like if I fly to another continent, can the FBI still come after me?
Yes, federal statutes can reach beyond our borders. By express provision, federal law can reach United States citizens while they are on foreign soil.
Really? Even in another country?
Yes. If you are a U.S. national, you carry certain obligations to your country no matter where you travel. Treason, for instance, can be committed by a U.S. citizen anywhere in the world.
Wow. What about the ocean? Like international waters where no country owns the land?
The federal government has what we call maritime jurisdiction. This extends to conduct by all persons aboard American ships. It also covers American aircraft.
Okay, so planes and boats.
Right. This applies when the ship or plane is on or over the high seas. Interestingly, it even applies when that American ship is sitting in foreign waters or docked in a foreign port.
Wait, even in a foreign port?
Yeah. The ship itself is treated almost like a floating piece of United States territory. If a crime happens on an American vessel, the federal government has the power to prosecute.
Okay, so to summarize federal power, they need to own the land. They need a specific rule from the Constitution, like the Commerce Clause, or it needs to involve an American citizen or an American ship abroad. That is a tight list of rules.
It is very specific.
Now let's contrast this with the states. Does a state need a special excuse from the Constitution to make a criminal law?
No. State power is vastly different and much broader. Every state has inherent authority. They do not need to point to a specific clause to justify making a law. They possess what is called the police power.
I always hear that term, police power. Does that just mean the power to hire police officers and buy police cars?
No, it's a much deeper concept than that. Police power is the fundamental right of a sovereign state to regulate its own internal affairs. The state uses this immense power to protect its citizens.
What does it cover?
Specifically, the police power allows a state to regulate four main things: health, safety, welfare, and morals.
Health, safety, welfare, and morals. That covers almost everything.
It does. It gives the state the power to pass almost any criminal law it wants, as long as it doesn't violate the Constitution. They can ban certain drugs to protect health. They can set speed limits to protect safety. They can regulate gambling to protect welfare and morals. The state has massive authority within its borders.
That is the catch, right? Within its borders. A state judge in Florida cannot punish a crime that happens entirely in Alaska. There has to be a geographic limit.
That is correct. And this brings us to a crucial vocabulary word for the MBE. Listeners, highlight this word in your notes. The word is situs. It is spelled S-I-T-U-S.
Situs. It sounds like the word site. What does it mean in criminal law?
It means exactly that, the site or the location. At common law, the rule was very strict. Only the state where the situs of the crime is located has jurisdiction. The state must be the actual site of the crime to have the power to punish.
But how do we define where the site actually is? Like, if I punch someone, the site is obviously where my fist connected with their face.
Yeah.
That's easy. But what if the crime is more complicated?
The general rule is that the situs is defined as the place where the prescribed act takes place.
Prescribed act.
Yeah, that just means the forbidden action. So, as you said, if the crime is battery, the situs is where the physical strike happened. But sometimes a crime is defined not just by an action, but by a result.
A result.
Right. If a crime includes a harmful result as a material element, the situs can be the place where that harmful result occurs.
Wait, I need to push back on this. It sounds like it could get very messy. What if I do something bad while standing in state A, but the actual harm happens over in state B? Which state is the situs? Which state has the power to arrest me?
That is a classic law school hypothetical, and the examiners love it. Let's use the libel example from our source text to explain how this works.
Okay, libel.
Libel is the crime of writing something false to maliciously damage someone's reputation.
All right, so let's set up the scenario. Let's say I live in state A. I sit down at my desk in state A, and I write a terrible false letter about my neighbor. I put a stamp on it, and I mail it to a major newspaper located across the border in state B.
Okay, tracking.
The newspaper receives the letter, prints it, and distributes it. Everyone in state B reads the lies. My neighbor's reputation is ruined.
Under the common law situs rules, we have to look at the elements of the crime of libel. The law says that a libelous statement is a crime where it is published.
Oh, where it's published?
Yes. The publication, the moment other people read it and the reputation is damaged, is the harmful result. It is not a crime merely where it is written. Writing private thoughts in a diary is not a crime. The act of publishing it to the world is the crime.
So even though I did all the physical writing in state A doesn't care.
Under strict common law, State A might not have jurisdiction because the harmful result did not happen there. State B is the situs. State B is where the publication occurred. State B is where the harmful result manifested. Therefore, State B has the jurisdiction to prosecute you, even though you never physically set foot in their state.
Wow, that is fascinating. The power follows the harm, not just the physical location of the criminal.
Exactly.
But you keep saying under the strict common law. I imagine states did not like this. States probably wanted more power to catch criminals who crossed borders. What are the modern rules?
You are exactly right. The strict situs rule caused a lot of jurisdictional nightmares as travel and communication became easier. So modern statutes have vastly expanded state jurisdiction.
How so?
States have written new laws to give themselves much broader reach. There are 4 modern conditions where a state can claim jurisdiction over you. Let's walk through them.
Well, let's take these slowly for the listeners' notes. What is the first modern rule of state jurisdiction?
The first rule is that a state has power if the offense is wholly or partly committed within the state.
Partly seems like a very vague word. How small of a part is enough?
It is extremely broad. Partly within the state means that if just one single element of the crime happens in the state, that is enough. Or if just the harmful result happens in the state, that is enough.
Really? Just one element?
Yes.
Okay.
For example, look at a homicide. The elements involve a physical act that causes a death. If the physical shooting happens in State A, but the victim is driven in an ambulance to a hospital in State B and dies there, both states have a claim.
Oh, wow.
State A has jurisdiction because the act happened there. State B has jurisdiction because the result, the death, happened there. Either state can prosecute.
So even a tiny fraction of the crime gives the state power. What is the second modern rule?
The second rule covers attempts and conspiracies that happen outside the state. Let's say you and a friend are sitting in a hotel room in Nevada. You are plotting and conspiring to rob a specific casino across the border in California.
Okay, we were just talking.
Right. All the talking, all the planning, all the map drawing happens in Nevada. That conduct is outside California.
Does California have jurisdiction over us while we are just talking in Nevada?
Not yet. But the modern rule says that if there is an attempt or conspiracy outside the state, plus one overt act committed inside the state gains jurisdiction.
An act inside.
Yes. So if you plan the robbery in Nevada, and then your friend drives across the border into California just to buy ski masks for the robbery, California now has jurisdiction over the entire conspiracy. An act outside plus one act inside equals power.
That makes sense. They need some physical connection to their territory. What is the third modern rule?
The third rule is the exact reverse. It's about attempts or conspiracies happening inside the state to commit a crime outside.
Okay.
You are sitting in New York, you hatch a plan to go commit a major fraud in London. All the planning happens in New York, but the target is in a foreign country.
Can New York prosecute me just for planning to break another country's laws?
Yes, New York has jurisdiction over your conspiracy, but there is a very important catch you must remember. The intended conduct must be an offense under the laws of both jurisdictions.
Both of them.
Yes, it must be illegal in New York, and it must also be legal in London. If you sit in New York and plan to do something in London that is perfectly legal in London, New York will not prosecute you for conspiracy. The harm has to be recognized by both.
Okay, the dual illegality rule. That is a great detail to note.
Yeah.
And what is the fourth and final modern rule for state jurisdiction?
The fourth rule deals with omissions. An omission is a failure to act when you have a legal duty to act. Let's say a state law imposes a specific legal duty on you. For example, a state law requires you to pay state income taxes, or a court order requires you to pay child support to a resident of that state.
And I fail to do it. I just ignore the law.
Exactly. If you fail to perform a legal duty imposed by a state, that state has jurisdiction to prosecute you for the omission. And here is the kicker. It does not matter where you are physically located at the time. Yes. You could be sitting on a beach in another country. Your physical location is irrelevant. The failure to act happened within the state that required the duty. Therefore, they have the power to punish you.
That is a massive amount of power. It really shows how states have closed the loopholes to ensure they can enforce their laws. Let's take a breath and recap this entire section.
Good idea.
Listeners, here are your MBE notes for jurisdiction. Jurisdiction means the power to punish. Federal power is limited. They need to own the land, like a national park. Or they need a constitutional hook, like interstate commerce. Or it must involve a U.S. citizen or ship abroad.
Right.
State power is much broader. States have police power to protect health, safety, welfare, and morals. Historically, state power was limited by situs, the exact site of the act or the result, but modern rules are much wider. Today, a state can punish you if even a tiny part of the crime happens there. If you plan outside but act inside, if you plan inside to act outside, or if you simply fail to do a legal duty required by that state.
A perfect summary. You have laid the foundation of power. Now we need to look at where that power is actually written down. We need to move to the sources of criminal law.
Right, so we know who has the power. We know the state has the physical reach to arrest you. But where do they get the actual words they use to charge you? Like, a police officer cannot just point at you and say, I think what you did is bad, so you're going to jail. There has to be a rule book. Where does the law come from?
To understand where the law comes from today, we have to look back at history. Early American law was not created from scratch. When the colonists came over, they brought English law with them. From the colonial period forward, American criminal law included a massive body of rules known as the English common law of crimes.
We mentioned common law earlier. Let's define it clearly for our listeners. What exactly is a common law crime?
A common law crime is deeply unique because it is a crime created entirely by a judge. It is enforced by the judiciary. There is no statute.
Okay, let's clarify what a statute is for our notes.
Sure, a statute is a formal written law passed by a legislative body, like Congress or a state assembly. Politicians vote on it, it gets written in a book, and everyone can read it.
Right.
But common law happens in the absence of a statute. Hundreds of years ago, a judge would look at a bad act, declare it a crime based on tradition and custom, and punish the offender. The next judge would copy the first judge. Over centuries, these judge-made rules built up into the common law.
That sounds incredibly arbitrary. A judge could just invent a crime because they felt like it.
It was certainly less predictable than a written statute, and that unpredictability is important. Let me ask you an MBE question. Given what we know about the limited power of the federal government, are there any federal common law crimes? Can a federal judge just invent a crime today?
Based on our earlier discussion about the Constitution, I'm going to say no. The federal government needs express permission.
You are absolutely correct. Listeners, write this down in big letters. There are no federal common law crimes.
None at all.
None. Federal criminal law is governed entirely by statute. A federal judge cannot invent a crime based on tradition. If Congress did not pass a statute, it is not a federal crime.
Wait, is there any tiny exception to that rule? The law always has exceptions.
There is one very narrow exception. Congress specifically provided for the survival of common law crimes in the District of Columbia. D.C. has a unique jurisdictional setup. But as a general nationwide rule, federal crimes must be statutory.
Okay, so the federal government relies on written statutes. What about the state governments? Do state judges still use the old common law to invent crimes?
This brings us to a massive modern trend. Over the last century, states realized that having unwritten judge-made crimes was unfair. People deserve fair notice of what is illegal. So the great majority of states decided to
I
modernize.
like that idea.
They enacted comprehensive criminal codes. They essentially gathered their legislatures, argued about every rule, and wrote down all their criminal laws in giant, organized books.
And what happened to the old common law crimes when they wrote these new books?
When they enacted these comprehensive codes, most states abolished common law crimes. They deleted them from the system. Some states abolished them explicitly, passing a law saying all common law crimes are hereby dead.
Just wipe them out.
Yeah. Other states abolished them by implication. They wrote a new code that was so comprehensive, courts assumed it was meant to completely replace the old judge-made rules. Today, in most states, if a crime is not written in the statute book, it is not a crime.
That seems much cleaner and fair. You just look in the book to see the rules. But earlier you warned me that the MBE is full of tricks. Is there a trap hiding in this modern trend?
Oh, there is a monumental trap here. It catches students every year. If we look closely at how legislatures operate, they're often imperfect. When the states were busy writing their shiny new criminal codes, they focused heavily on defining the crimes: murder, theft, arson.
Right, the bad acts.
Exactly. They abolished the old common law crimes to make way for the new statutes. But they often forgot a crucial piece of the puzzle. They forgot to write down the defenses.
What do you mean they forgot the defenses? Give me an example of a common law defense.
Think about the defense of insanity, or the defense of necessity. Necessity is when you break the law to avoid a greater harm, like stealing a boat to escape a massive flood.
Okay, yeah.
For centuries, these were common law defenses created by judges to ensure justice. But when legislatures wrote the new codes, they sometimes forgot to include a specific statute detailing the rules of insanity or necessity.
So what happens? Does a defendant in a modern court just lose the right to argue necessity because the legislature forgot to put it in the new book?
No. And this is the MBE trick. Even if a state abolishes common law crimes, the old common law defenses survive unless a statute explicitly says otherwise.
Wow.
Yeah. If the new code is silent on insanity, the courts will reach back into history and apply the old judge-made common law rules for insanity.
Listeners, put a huge star next to that in your notes. Common law crimes are mostly dead and replaced by statutes. But common law defenses are alive and well if the statute is silent. That is a brilliant distinction.
It's a very common test question.
Okay, let's talk about the highest law in the land. Does the United States Constitution itself contain any crimes?
The Constitution is generally a document that grants and limits power. It is not a criminal code. In fact, it only defines one single crime. Just one.
What is it?
Treason.
Treason. The crime of betraying your country. How exactly does the Constitution define it?
Article 3 of the Constitution defines treason very narrowly. It consists only in levying war against the United States or in adhering to their enemies, giving them aid and comfort.
Why did the founders put this one specific crime directly into the Constitution? Why not just let Congress write a treason statute later?
Because the founders were terrified of how the crime of treason had been abused in history. In England, the king would routinely accuse his political rivals of treason based on flimsy rumors, whispered conversations, or fake evidence. It was a tool for tyranny.
That makes sense.
The founders wanted to ensure that no American government could ever use a treason charge to silence political opposition. So they put the definition directly in the Constitution so Congress couldn't expand it, and they placed severe limits on how it could be proven.
How hard is it to prove treason? What are the limits?
It is arguably the hardest crime to prove in the American legal system. The Constitution mandates that no person can be convicted of treason unless there is testimony from two separate witnesses, and these two witnesses must testify to the exact same overt act.
Wait, they have to see the exact same moment. If witness A sees me hand a map to a spy on Monday, and witness B sees me give money to a spy on Tuesday, is that enough?
No. That is not enough. You have two witnesses to treasonous behavior, but you do not have two witnesses to the same overt act. Both witnesses must stand in court and say, I saw him hand over the map on Monday. It requires dual verification of a single event.
That is an incredibly high bar. What if the government cannot find two witnesses? Is there any other way to convict?
The only other way is a confession. But not just a confession in a police interrogation room. It must be a confession in open court before a judge. The founders made it extraordinarily difficult to put someone to death for treason.
That historical context makes the rules so much easier to remember. Okay, let's move to another source of law. We have common law, statutes, and the Constitution. Are there any other places where criminal rules are made?
Yes, and this source is becoming increasingly dominant in modern life. Administrative crimes. Our society has become incredibly complex. The legislature cannot possibly write a specific statute for every tiny detail of modern industry, so they create administrative agencies.
Give me an example of an agency.
Think of the SEC, the Securities and Exchange Commission, which regulates the stock market, or the EPA, the Environmental Protection Agency, which regulates pollution. The legislature will pass a broad statute delegating power to these agencies. They give the agency the authority to prescribe detailed rules and regulations.
So Congress says, EPA, we want clean air. Go write the specific rules about factory smoke. And the EPA writes the rules. But if a factory owner breaks an EPA rule, is it an actual crime? Can they go to jail?
Yes, the violation of an agency rule may be punishable as a crime. The source text uses the SEC as an example. The SEC adopts highly technical anti-fraud rules for trading stocks. If a broker violates those specific agency rules, it can result in severe criminal liability, including years in federal prison.
I have to pause and push back on this. This sounds deeply undemocratic and slightly dangerous. We elect Congress to make our laws, but we do not elect the bureaucrats at the SEC or the EPA. Can an unelected agency just invent a rule and then decide to throw me in prison for breaking it? Where are the limits?
Your concern is exactly why the courts have placed strict constitutional limits on administrative crimes. The legislature can delegate the power to make the rule, but there are two massive things they cannot delegate. First, the legislature may not delegate the power to determine the penalty. The agency cannot decide if breaking their rule results in a fine or probation or 10 years in prison. The elected legislature must write a statute stating anyone who breaks a valid SEC rule faces up to 5 years in prison. The agency writes the technical rule, but Congress sets the punishment.
That makes me feel a bit better. The elected officials still control the jail time. What is the second thing the agency cannot do?
The agency cannot delegate the power of adjudication. Adjudication is the formal process of determining guilt or innocence. An administrative agency cannot run a criminal trial.
So they can't be the judge.
Exactly. They cannot act as the judge and jury, declare you guilty, and send you to a cell. Only a true constitutional court can adjudicate criminal guilt. The agency's role is strictly limited to making the technical rule.
Okay, the agency makes the rule, Congress sets the penalty, and a real judge runs the trial. That is a vital separation of powers to keep in mind. Finally, our source material keeps mentioning the MPC, the Model Penal Code. Let's define what this actually is, because it sounds like a source of law, but earlier you said it wasn't.
That is a very common point of confusion. The MPC was published in 1962 by the American Law Institute. It is vital to understand what it is not. It is not a statute. It was never voted on by Congress or any state legislature. It is not a binding law anywhere.
If it is not a law, why does the bar exam test it so heavily? Why do law students spend so much time studying a book of non-laws?
Because it is the most influential scholarly endeavor in the history of American criminal law. Before 1962, state criminal laws were a chaotic mess of old common law, confusing statutes, and contradictory rules. A group of the most brilliant legal scholars and professors got together and said, let's write a perfect, modern, coherent body of criminal law. Let's show the states what a logical code should look like. They spent years drafting the Model Penal Code.
So it was essentially a template for the states to copy.
Exactly, and it was a massive success. Since 1962, the MPC has greatly influenced the drafting of new state codes. Many states looked at the MPC's enlightened, logical positions on things like mental states and attempt, and simply copied the text directly into their own statutes.
They just pasted it in.
Right. It brought order to chaos. That is why it may be the single most important source of general criminal law principles today, and why the MBE expects you to know its key doctrines.
That is a brilliant explanation. It is the gold standard template. Let's take a moment for our Section 3 recap. Listeners, here are your notes on sources of law. Early America used common law, which are crimes invented by judges. Today, most states have abolished common law crimes and replaced them with written statutes.
Correct.
But watch out for the trap. Common law defenses often survive. There are no federal common law crimes. Everything federal must be a statute. The Constitution only defines one crime, treason, and it requires 2 witnesses to the exact same act. Administrative agencies can write rules that carry criminal penalties, but they cannot decide the punishment or run the trial. Finally, the Model Penal Code is not a law, but a highly influential scholarly template that shaped modern state statutes.
A very thorough recap. We know where the law comes from. Now we must ask a much deeper philosophical question.
Yes, we know a rule was broken. We know the state has the power to act. But why do we do it? When the judge bangs the gavel and sentences a human being to spend 10 years in a concrete cell, what is society's goal? This brings us to Section 4, Theories of Punishment and Classifications. Let's start with the philosophy. Why do we punish people?
Historically, scholars and lawmakers have debated this endlessly. Our source lists 6 primary theories that are advanced to justify criminal punishment. A good lawyer needs to understand these theories because judges often rely on them when deciding how harsh a sentence should be. We will break them down using simple English and real-world scenarios.
Let's walk through the 6 theories. What is the first justification for locking someone up?
The first theory is incapacitation. Sometimes you will hear it called restraint. The goal here is purely mechanical. We want to keep the criminal locked away from the public. While they are imprisoned behind a massive wall, they have fewer opportunities to commit acts that cause harm to society.
So this theory does not care if the person learns a lesson. It just removes a dangerous object from the room.
Exactly. If a serial killer is in a maximum security prison, he cannot harm citizens on the street. The goal is simply to physically restrain the danger.
That is very straightforward.
Yeah.
What is the second theory?
The second theory is special deterrence. This theory focuses entirely on the psychology of the specific criminal standing in front of the judge. The punishment is designed to inflict enough pain or loss of freedom to teach them a lesson. The hope is that the memory of the punishment will deter this specific individual from committing future crimes when they are released.
So if I steal a car and the judge gives me a year in a miserable prison, the goal is that 5 years from now, when I see an empty car with the keys in it, I will remember the misery of prison and walk away. It is meant to fix my specific decision-making process.
Precisely. Special deterrence targets the individual. Now contrast that with the third theory, which is general deterrence. This theory is not really about the criminal being punished at all. It is about everyone else watching.
How does that work? We punish person A to send a message to person B?
Yes. The punishment is meant to be a public warning. By inflicting a harsh penalty on the offender, society hopes to scare other people. When members of the general public see the consequences, they will fear incurring the same punishment. This fear will deter them from breaking the law.
Let's use a modern example. When the government cracks down on a famous celebrity for tax evasion and sends them to federal prison, they want that on the front page of every newspaper.
Exactly.
They want every normal citizen doing their taxes in April to think, wow, if they went to jail, I better not cheat on my deductions. That is general deterrence.
A perfect example. They are making an example of the celebrity to manage the behavior of the masses.
Okay, what is the fourth theory of punishment?
The fourth theory is retribution. This is perhaps the oldest and most primal justification. It is not about protecting the future, it is about balancing the scales of the past. Retribution is about revenge. When a horrific crime occurs, society is outraged. The social order is broken. Punishment is imposed simply to vent society's sense of outrage and to make the criminals suffer proportionately for the harm they caused.
So it is the classic an eye for an eye. If you took a life, we take your life. It is not about teaching a lesson, it is about paying a moral debt.
Exactly. Retribution satisfies a deeply ingrained human need for justice and vengeance. Now let's swing to the opposite end of the philosophical spectrum for the fifth theory. Rehabilitation.
Rehabilitation sounds much more modern and optimistic.
It is. The theory of rehabilitation views the criminal not as a monster to be caged, but as a broken person who needs fixing. The idea is that imprisonment should provide an opportunity to mold or reform the offender. Perhaps they need drug treatment or psychological counseling or job training. The ultimate goal is that upon their return to society, they will conform their behavior to societal norms and become a productive citizen.
So we use the time in prison to cure the underlying disease that caused the crime.
That is the hope, although the effectiveness of rehabilitation in modern prisons is highly debated. Finally, we reach the sixth theory, education.
Education. How does sending someone to prison educate anyone? Is this the same as general deterrence?
It is similar, but more subtle. General deterrence relies on fear. Education relies on moral instruction. The public trial, conviction, and sentencing of criminals serve to educate the public on society's values. It draws a bright line between acceptable and unacceptable behavior. Over time, watching this process helps develop a deeply ingrained respect for the law within the culture. It teaches citizens the moral difference between right and wrong.
Those are 6 fascinating lenses to view punishment through: restraint, specific fear, revenge, fixing the broken, and moral education.
They give you a lot to think about.
Now, once the judge decides to punish someone, the crime is given a label. How do we classify crimes? What is the actual difference between a felony and a misdemeanor?
Let's begin with how most courts handle this today. Under the modern rule, crimes are classified purely based on the severity of the potential punishment. The legislature draws a hard line based on time.
What is the line for a felony?
A felony is the most serious classification. Under modern statutes, a felony is any crime punishable by death or punishable by imprisonment exceeding 1 year. If the statute says you can go to prison for a year and a day, it is a felony.
And a misdemeanor.
Misdemeanors are lesser offenses. A misdemeanor is a crime punishable by imprisonment for less than 1 year. Often, they are punishable only by a fine or perhaps probation. The 1-year mark is the dividing line in modern law.
That seems incredibly simple to apply. But this is the bar exam we are talking about. There have to be a historical catch.
You are right to be suspicious. For the MBE, knowing the modern rule is not enough. You must also memorize the common law classification. At common law, centuries ago, the difference between a felony and a misdemeanor had absolutely nothing to do with how many years you spent in prison.
Why not? What was it based on?
It was based on a very specific, rigid list. At early common law, almost all felonies were punishable by death. Because the penalty was so severe, the judges limited felonies to a very specific list of the most horrific crimes.
Okay, listeners, put down your coffee. You need to write this list down and memorize it. What were the specific common law felonies?
There are exactly 9 of them: murder, manslaughter, rape, sodomy, mayhem, robbery, larceny, arson, and burglary. Those 9 crimes, and only those 9 crimes, were felonies at common law.
Let me repeat that slowly for the notes. Murder, manslaughter, rape, sodomy, mayhem, robbery, larceny, arson, burglary. If a crime is not one of those 9, what was its classification?
At common law, every other crime, no matter how damaging or terrible it might seem, was classified as a misdemeanor. If an MBE question asks about common law classifications, you must search your memory for those 9 specific words.
That is a fantastic memorization tip. Now, our source text introduces another set of classifications, and this involves Latin terms. Let's break them down. Malum in se versus malum prohibitum. What is the fundamental difference here?
These terms describe the moral nature of the crime. Let's start with malum in se. This Latin phrase translates roughly to wrong in itself. A crime that is malum in se is one that is considered inherently evil. It is an act that is morally wrong by its very nature, regardless of whether a law is written down or not.
Why is it inherently evil? What makes an act malum in se?
Generally, a crime is malum in se for 2 reasons. First, because criminal intent, a guilty mind, is a required element of the offense. The person intended to cause harm. Second, because the crime involves what the law calls moral turpitude. It offends the basic moral standards of society.
Let's put some real-world actions to these labels. Let's imagine a character. Let's call her Sarah. What could Sarah do that would be malum in se?
If Sarah intentionally strikes another person with a baseball bat, that is battery. Battery is malum in se. It is naturally, inherently wrong to assault someone. If Sarah sneaks into her house and steals money, that is larceny. Larceny is malum in se. Stealing is inherently wrong. If Sarah gets completely drunk and drives her car down a crowded sidewalk, drunken driving is considered malum in se because it shows a depraved indifference to human life. These acts are universally recognized as evil.
Okay, I understand malum in se. Now contrast that with malum prohibitum.
Yeah.
What does that mean for Sarah?
Malum prohibitum means wrong because it is prohibited. A crime that is malum prohibitum is not inherently evil. It does not involve a guilty, malicious mind or moral turpitude. It is an act that is only considered wrong because the legislature passed a statute saying it is wrong. It is a regulatory rule designed for an orderly society.
Give me examples of Sarah committing a malum prohibitum crime.
Let's say Sarah goes fishing, but she forgets to renew her state fishing license. Hunting or fishing without a license is a crime, but it is malum prohibitum. She is not evil, she just broke a bureaucratic rule. Or suppose Sarah is driving to work on a clear, empty highway. The speed limit is 55, but she is driving 65. Speeding is a crime, but it is malum prohibitum. It is not an inherently wicked act, it is just a violation of a traffic regulation. Or imagine Sarah manages a pharmacy and she accidentally mislabels a bottle of aspirin, violating the Federal Drug Labeling Act. That is a strict liability regulatory offense. It is malum prohibitum.
I see the distinction perfectly. Hitting someone with a bat is evil. Forgetting your fishing license is just breaking a rule. But why does the law bother with these Latin labels? Do they actually matter in a courtroom, or are they just academic theories?
These labels have massive, life-altering real-world impacts. They dictate collateral consequences that go far beyond just serving your prison sentence. Let's look at the concept of infamous crimes and moral turpitude.
Our source mentions infamous crimes. What makes a crime infamous?
At common law, infamous crimes were a specific category of offenses that involved severe dishonesty. They included all crimes involving fraud, deceit, or the intentional obstruction of justice, like perjury, lying under oath. Under modern law, many states have expanded the definition of an infamous crime to encompass almost all serious felonies.
And we mentioned moral turpitude earlier regarding malum in se crimes. What happens to a person who is convicted of an infamous crime or a crime of moral turpitude?
The collateral damage is severe. First, consider immigration. If an alien or a permanent resident is convicted of a crime involving moral turpitude, federal law may dictate that it results in their deportation. They can serve their sentence and then be immediately kicked out of the country.
Wow, so stealing a car could get you deported, but speeding probably wouldn't.
Yeah.
What about professional consequences?
It is devastating for professionals. If an attorney is convicted of a crime involving moral turpitude, like embezzlement or fraud, it will almost certainly result in disbarment. They will lose their license to practice law forever because they have proven they cannot be trusted.
And what if the convicted person is just a witness in someone else's trial?
This is a huge rule for evidence. If a witness takes the stand, the opposing lawyer can attack their credibility. If that witness has a prior conviction for an infamous crime like perjury or fraud, the jury is allowed to hear about it. The logic is that if they lied before, they might be lying now. The conviction ruins their credibility as a witness. These labels follow you for the rest of your life.
That makes the distinction between malum in se and malum prohibitum incredibly important. Let's pause for our Section 4 recap. This is a big one for your notes. We discussed 6 theories of punishment incapacitation, which is locking them up, special deterrence, scaring the criminal, general deterrence, scaring the public, retribution, revenge, rehabilitation, fixing the criminal, and education, teaching moral values.
Spot on.
For classifications, the modern rule is simple. A felony is any crime with a punishment of more than 1 year. Misdemeanors are less than a year. But remember the common law trick. There are only 9 common law felonies: murder, manslaughter, rape, sodomy, mayhem, robbery, larceny, arson, and burglary. Everything else was a misdemeanor. Finally, malum in secens, crimes are inherently evil. Malum prohibitum crimes are just regulatory rules. If a crime involves moral turpitude or is infamous, it can lead to deportation, disbarment, or a ruined reputation in court.
That covers the theories and labels beautifully. Now we must turn to the ultimate shield for the citizen. We need to talk about the Constitution again.
We've established that the government has immense power to punish. They can put you in a cage, deport you, and ruin your life. But this is America. The government cannot just act randomly. They must play by a strict set of rules. This brings us to Section 5, Constitutional Limits, and the principle of legality. How does the Constitution protect the average citizen from an overzealous prosecutor?
The Constitution places profound limits on how legislatures can create crimes. The overriding theme is fairness and notice. Let's start with a foundational protection, the void for vagueness doctrine.
Void for vagueness. That sounds like a judge saying, this law is too confusing, so I'm throwing it in the trash.
That is essentially what it is. The doctrine stems from the due process clauses found in the 5th and 14th Amendments of the Federal Constitution. The Supreme Court has repeatedly ruled that due process requires fair notice. No criminal penalty can be imposed if the citizen did not have a fair opportunity to know that their conduct was forbidden. If a statute is written so poorly or broadly that its meaning is a mystery, it is declared void. It is unconstitutional.
How confusing does a law have to be to get thrown out? Are there specific tests the courts use?
Yes, the source text notes that the void for vagueness doctrine incorporates 2 primary considerations. Both must be satisfied.
What is the first consideration?
The first is the concept of fair warning. A criminal statute must be written clearly enough to give a person of ordinary intelligence fair notice of what conduct is forbidden.
Notice you said ordinary intelligence. So you shouldn't need a law degree to understand the rule.
Exactly. If an average citizen reads the statute and honestly cannot figure out what they are allowed to do and what will get them arrested, the law fails the fair warning test. Citizens should not have to guess at the meaning of criminal laws.
That protects the citizen reading the law. What is the second consideration?
The second consideration focuses on the police. A statute must not be written so broadly that it encourages arbitrary and erratic arrests and convictions.
Give me an example of a law that encourages arbitrary arrests.
Think about the old vagrancy or loitering laws from the mid-20th century. Some cities passed laws saying it was a crime to wander the streets without a clear purpose.
That sounds incredibly vague. Who defines what a clear purpose is?
Exactly. Because the law was so vague, it gave the police infinite discretion. An officer could look at a teenager standing on a corner and say, "You don't have a clear purpose, you're under arrest." But they might ignore a businessman standing on the same corner. The vagueness allowed the police to arbitrarily arrest anyone they didn't like. The Supreme Court strikes these laws down because criminal statutes must have clear, objective boundaries to prevent discriminatory enforcement.
Listeners, pay close attention to this next point. The void for vagueness doctrine is powerful on its own, but it becomes an absolute weapon when it interacts with the First Amendment. If a criminal statute is vague, A&D, it touches upon protected free speech, the courts will scrutinize it relentlessly. They do not want citizens to be afraid to speak just because a law is confusing.
That is a crucial MBE insight. The courts will protect free speech aggressively against vague laws. Now let's examine another constitutional shield. Article 1 of the Constitution expressly prohibits both the federal government and the states from passing ex post facto laws.
Ex post facto. This is the dystopian scenario I mentioned at the very beginning of the deep dive. What does this Latin phrase mean?
Ex post facto translates directly to after the fact. An ex post facto law is a statute that operates retroactively. It works backward in time, changing the legal consequences of actions that were committed before the law was even passed.
Why is this so dangerous?
Because it destroys the concept of fair notice. How can you choose to follow the law today if the legislature can just change the rules tomorrow and punish you for what you did today? To define exactly how this works, the Supreme Court laid out 4 specific rules in a famous old case called Calder v. Bull. If a retroactive law does any of these 4 things, it is unconstitutional.
Let's walk through the 4 rules of Calder v. Bull slowly, using a hypothetical character. Let's use Bob. What is the first way a law can be an illegal ex post facto law?
Rule 1. The law works backward to make criminal an act that was innocent when it was done. Let's say Bob legally buys a specific type of pocket knife on Monday. It is completely lawful. On Tuesday, the legislature passes a new statute banning that knife, and they make the law retroactive to last week. The police arrest Bob on Wednesday for the purchase he made on Monday.
That is blatantly unfair. Bob followed the rules on Monday. The government cannot change the past to make him a criminal? What is the second rule?
Rule 2. The law works backward to aggravate a crime or makes the punishment greater than it was when the crime was committed. Let's say Bob commits a minor theft on Monday. The maximum penalty on the books is a $500 fine. On Tuesday, the legislature amends the theft statute, changing the penalty to 5 years in prison. They try to apply the new prison sentence to Bob's Monday crime.
They cannot do that. He might have weighed the risk of a $500 fine, but he never agreed to risk 5 years in prison. They can only punish him with the law that existed the moment he broke it. What is the third rule?
Rule 3 involves the courtroom. A law is ex post facto if it works backward to change the rules of evidence to the detriment of criminal defendants. It requires less or different evidence to convict than the law required at the time the offense was committed.
How does changing evidence rules hurt Bob?
Suppose when Bob committed his crime on Monday, the law strictly required the testimony of 2 eyewitnesses to secure a conviction. The prosecutor only has 1 witness against Bob. So on Tuesday, the legislature changes the rule, allowing convictions based on just 1 witness, and applies it to Bob's upcoming trial.
They are moving the goalposts during the game.
Huh.
By lowering the burden of proof retroactively, they are making it easier to convict him for a past act. That is unconstitutional. And what is the 4th and final rule?
Rule 4. The law alters the law of criminal procedure to deprive criminal defendants of a substantive right. Suppose on Monday, the law guaranteed Bob the right to a jury of 12 people. On Tuesday, a new law reduces juries to 6 people to save money and applies it to Bob. The courts often view the loss of such a substantive procedural right retroactively as an ex post facto violation.
So all 4 rules of Calder v. Bull are essentially saying the same thing. The government cannot change the rules of the game after the play is over, if that change hurts the defendant. That is a massive protection. Now, our source lists one more constitutional limit in this section. No bills of attainder. What in the world is a bill of attainder?
A bill of attainder is another tyrannical tool from English history that the founders explicitly banned. A bill of attainder is a legislative act, a law passed by Congress or a state assembly that inflicts punishment on a specific named individual or a specific group without giving them a judicial trial.
So the legislature just votes to punish someone directly.
Exactly. Imagine Congress passing a law that says, Bob Smith is a traitor and his house is hereby confiscated by the government. Congress acts as the prosecutor, judge, and jury all at once. They skip the courts entirely.
Let me make sure I understand the difference here, because ex post facto and bills of attainder sound similar. Both involve unfair legislative actions. But is the key distinction the trial itself? If the legislature passes an ex post facto law, they change the rules unfairly, but they still have to send Bob to a real courtroom to face a judge, right?
You have hit the nail on the head. That is the exact distinction. An ex post facto law provides unfair rules, but it does not deprive the offender of a judicial trial. A bill of attainder bypasses the entire judicial branch. The legislature essentially pronounces guilt and executes the sentence themselves. The Constitution strictly forbids this to maintain the separation of powers. The legislature makes the laws. The courts conduct the trials.
That is a very clear and important distinction for the MBE. Let's do our Section 5 recap. We are talking about constitutional shields. First, laws must be clear, not vague. This void for vagueness doctrine ensures citizens have fair warning and stops police from making arbitrary arrests. It is especially strong if free speech is involved. Second, no ex post facto laws. The government cannot pass a law that goes backward in time to make an innocent act criminal, increase a punishment, or lower the evidence needed to convict you. They cannot change the rules after the fact. Third, no bills of attainder. The legislature cannot pass a law that bypasses the courts and punishes you directly. They must give you a trial.
That is a perfect summary of constitutional limits. But even when a law is perfectly constitutional, clear, and perspective, a massive problem remains. Laws are made of words, and words are inherently messy.
Exactly. Lawyers make their living arguing over what words mean. A statute might say vehicle, but does that mean a car, a bicycle, or a skateboard? How do judges decide what a statute actually means when the defense and the prosecution disagree? This brings us to Section 6, statutory interpretation. How do we read the fine print?
Statutory interpretation is the daily bread and butter of criminal courts. There are established rules and maxims that judges use to decipher the legislature's intent. Let's start with the most fundamental rule of all. It is called the plain meaning rule.
What is the plain meaning rule?
It is the starting point for every analysis. The rule states that when the statutory language is plain and its meaning is clear, the court must give effect to it. You do not look for hidden meanings. You do not look at the history of the law. You just read the words on the page using their ordinary, everyday definitions.
But what if a judge reads the plain words and realizes the law is terribly written? What if the judge thinks the law is stupid or unwise or terrible public policy? Can the judge ignore the plain words to achieve a better result?
Absolutely not. The judge must follow the plain words. The judge's job is not to fix bad legislation. The legislature, elected by the people, chose those specific words. It is not within the province of a court to question the wisdom or desirability of a clear statute. They must apply it as written.
Is there absolutely no exception? What if applying the plain words leads to a complete disaster?
There is one, a very narrow exception. The court will abandon the plain meaning only if applying the literal words would lead to an absurd consequence or create a profound, undeniable injustice that the legislature clearly could not have intended. But absent true absurdity, the plain meaning wins every time.
Okay, the plain meaning is step one. But what if the words are not plain? What if the statute is genuinely ambiguous?
This brings us to perhaps the most important rule of interpretation for criminal defendants. Listeners, put a massive star next to this. It is called the rule of lenity. Lenity means mercy or leniency.
How does the rule of lenity work?
The rule requires that if a criminal statute is ambiguous, it must be strictly construed in favor of the defendant. The court must interpret the words in a way that creates the least amount of criminal liability. In simple terms, if there is a tie, the tie goes to the defendant.
Why do we give the tie to the criminal? That seems generous.
It is about the balance of power. The government has all the resources. They have the police, the prosecutors, and the power to draft the laws. The defendant just has their life on the line. The philosophy is that if the government wants to take away a citizen's freedom, it is the government's responsibility to write a clear law. If the legislature was sloppy and wrote an ambiguous law, the state must bear the burden of that mistake, not the citizen.
That is a powerful philosophical protection. But let me clarify a vocabulary word. Earlier, we talked about laws that are vague. You said a vague law is unconstitutional and thrown in the trash. Now we are talking about laws that are ambiguous. What is the legal difference between vague and ambiguous?
This is a critical distinction for the bar exam. Do not confuse the two. A vague statute is one that is so hopelessly unclear, so poorly written, that it is susceptible to no reasonable interpretation at all. It is just word soup. Because it offers no fair warning, a vague statute is unconstitutional and void.
And an ambiguous statute.
An ambiguous statute is well written enough to be constitutional, but the specific words are susceptible to two or more equally reasonable interpretations. There are two fair ways to read it. One reading helps the prosecutor, one reading helps the defendant. It is not void, it is just tied. And because of the rule of lenity, the judge breaks the tie in favor of the defendant. Vague equals void. Ambiguous equals tie goes to the defendant.
That makes perfect sense. Okay, now I have to attempt to pronounce another Latin phrase from our source text. Expressio unius, exclusio alterius. I know I butchered that. What does this maxim mean in plain English?
The pronunciation does not matter. The logic does. The translation is the expression of one thing impliedly indicates an intention to exclude another. It is a logical deduction about what the legislature was thinking when they wrote the list.
I am still a bit lost. Let's use the example from the source text. The bigamy example. This is a classic. You set up the law for me.
Let's break it down. A state legislature writes a criminal statute defining bigamy. The general rule of the statute is simple. Bigamy is the act of remarriage by a person who already has a living spouse. You cannot be married to two people at the same time. If you do, you go to jail.
Okay, that is the general prohibition.
But the legislature realizes life is complicated. Sometimes people vanish. So in the very next sentence of the statute, they write down an explicit exception. The statute says, however, this law does not apply to a person whose spouse has disappeared and been absent for more than 7 years.
Okay, if your husband goes out for milk, disappears without a trace, and 7 years go by, the law assumes he is dead. You can safely remarry without going to jail for bigamy. I understand the rule and the written exception. So what is the legal debate?
The debate arises when real life doesn't fit the neat categories. What happens to a woman whose husband disappeared in a terrible plane crash in the ocean? They never found the body, but everyone knows he is dead. She waits 5 years. She genuinely, in complete good faith, believes her husband is dead. She remarries at year 5.
Can the prosecutor charge her with bigamy? It seems incredibly harsh. She truly believed he was dead. Shouldn't there be a good faith belief exception?
Most jurisdictions will say no. She is guilty of bigamy. And the reason is our Latin maxim, the expression of one thing excludes another.
Walk me through the logic. Why does the maxim condemn her?
The judge looks at the statute. The judge says, the legislature sat down and thought about exceptions to the bigamy rule. We know this because they wrote one down. They explicitly expressed the 7-year absence rule. Because they expressed that one specific exception, we must legally assume they intentionally meant to exclude all other possible exceptions.
Because they wrote down 7 years, it implies they actively rejected 5 years with good faith.
Exactly. If the legislature wanted a good faith exception, they would have written it next to the 7-year exception. The expression of the 7-year rule excludes the good faith rule. It is strict, but it is a very logical way to interpret a text.
That is a great example of how reading the fine print can land you in prison. Let's look at another problem. What happens when the legislature writes too many laws and the laws start fighting with each other? What if two statutes contradict each other?
We have rules for statutory conflicts as well. The two big maxims are the specific controls the general, and the more recent controls the earlier.
Let's illustrate specific over general first. Give me an example.
Let's say Chapter 1 of the State Code contains a very broad general statute. It reads, all forms of gambling are strictly prohibited in this state. No exceptions mentioned. But over in Chapter 50 of the Code, there is a very narrow specific statute. It reads, registered churches may hold charity raffles.
Those laws clearly conflict. A raffle is gambling. So if a church holds a raffle, do the police arrest the priest?
No. The judge will apply the maxim. The specific statute permitting church raffles will control over the general statute banning all gambling. The logic is that when the legislature read the specific rule about churches, their attention was laser-focused on that one exact issue. Therefore, their specific intent overrides their broad general intent. The church can hold its raffle.
Specific intent beats general intent. Got it. Now let's do new over old. The more recent controls the earlier.
Imagine a timeline. In 1975, The legislature passes a statute that says cigarette manufacturers may spend up to $1 million a year on billboard advertising. This law limits their budget but allows the advertising. 5 years later, in 1980, the legislature passes a new statute. It reads, all billboard advertising of cigarettes is completely banned.
A cigarette company puts up a billboard in 1981. They point to the 1975 law and say, look, we are allowed to spend $1 million. Who wins?
The government wins. The 1980 statute will govern. It is more recent in time. The courts presume that the legislature knew about the old 1975 law, and by passing a contradictory law in 1980, they intended to implicitly override or repeal the old one. The newest expression of the legislature's will always controls.
That makes chronological sense. Speaking of repealing laws, we have one more topic in this section. What happens if the legislature realizes a law is terrible and they just delete it entirely? They repealed the statute.
This is a fascinating area involving timing and justice. At common law, the rule for repeals was very dramatic. In the absence of a saving provision, the repeal of a criminal statute operates to instantly bar all prosecutions for earlier violations.
Break that down for me. What does that mean in practice?
Let's say that until yesterday it was a crime to wear a red hat. You wore a red hat last week and the police arrested you. Your trial is scheduled for tomorrow. But today, the legislature repeals the red hat law. They delete it from the books. Under the common law rule, the moment the law is deleted, your pending prosecution dies with it. The charges against you must be dropped immediately. The court loses the power to try you.
That seems fair. Society decided wearing a red hat isn't bad anymore, so why should I have to go to trial for it? But wait, what if my timing was worse? What if my trial finished last month, and I am already sitting in prison serving a 5-year sentence for wearing a red hat? Does the warden unlock my cell today?
No, and this is the harsh reality. A repeal will not operate to set free a person who has already been prosecuted and convicted. If your judgment has become final and your appeals are exhausted, you stay in jail. The repeal only halts pending or future prosecutions. It does not undo a finalized court judgment.
That is brutal luck.
Yeah.
But you said that was the old common law rule. What happens today? Is it different?
Yes. Most modern legislatures do not like the idea of criminals getting off on a technicality of timing. So instead, these include a saving provision.
What does a saving provision do? Who is it saving?
It saves the prosecutor's cases. A saving provision is a small clause attached to the repeal. It essentially says, we are deleting this law today. However, any crimes committed prior to today are still subject to prosecution and punishment under the old law.
So even though the red hat law is deleted today because I broke the law last week when it was still active, the prosecutor can still take me to trial tomorrow.
Exactly. The saving provision creates a ghost of the old law that only applies to actions committed in the past. It keeps the old law alive just long enough to punish you.
That is a critical technicality. Time for our Section 6 recap. We covered statutory interpretation. Rule 1, read the words normally. The plain meaning rule wins unless it creates pure absurdity. Rule 2, the rule of lenity. If a law is genuinely ambiguous, meaning it has two fair interpretations, the tie goes to the defendant. Rule 3, expressio unius. If the law writes down one specific exception, it implies there are no other unwritten exceptions. Rule 4, specific laws override general laws, and new laws override old laws. Finally, if a law is repealed, pending cases are dropped unless the legislature included a saving provision to keep the old prosecutions alive.
A fantastic summary. You have navigated the constitutional limits and the wording of the statutes. We are now ready for the final and undoubtedly the trickiest section of our deep dive.
This is the big one. Section 7, the double jeopardy trap. On the outline, it is called merger. The MBE examiners love to lay this trap. You do one bad thing, it's one continuous event. But an overzealous prosecutor charges you with 3 different crimes for that single act. The question is, when do these multiple crimes merge together so you only get punished once? And when can the prosecutor stack them up and put you away for life?
This area is fundamentally about protecting citizens from multiple convictions and multiple punishments for the same behavior. And just like everything else, we have to start by understanding the common law rule because it sets the stage.
How did the old common law handle a prosecutor charging multiple crimes for one act?
At common law, there was a very specific, rigid merger rule. If a person engaged in conduct that constituted both a felony and a misdemeanor, she could be convicted only of the felony. The misdemeanor was regarded as merged into the felony.
Can you give me an analogy? How should I visualize this?
Think of the felony as a massive ocean and the misdemeanor as a single drop of water. When the drop of water hits the ocean, it disappears. It loses its independent identity. The smaller crime is completely swallowed by the larger crime. You only go to trial for the felony.
But what if the person committed two massive crimes? Did felonies merge into other felonies?
No. That is a vital distinction.
Mm.
At common law, if the same act constituted several felonies, there was absolutely no merger. You could be convicted of both. Likewise, if the act constituted several misdemeanors, there was no merger. The rule only applied when a misdemeanor met a felony.
Okay, that was the old rule. But the modern rule is very different, isn't it?
Completely different. The general rule in modern American law is that there is no merger. Let me repeat that. Generally, crimes do not merge. You can be charged, convicted, and punished for multiple crimes arising from the exact same physical act. However, because this can lead to massive injustice, the courts and the Constitution have carved out limited, highly specific exceptions. For the MBE, you must memorize these specific exceptions.
Let's break these exceptions down, one by one. What is exception number 1?
Exception 1 deals with inchoate crimes. Inchoate is a fancy legal word for incomplete. It means you tried to do something or you planned to do something, but you didn't quite finish the ultimate goal. The law punishes the attempt because you showed dangerous intent.
The source material specifically mentions the crime of solicitation. How does solicitation work with merger?
Solicitation is the act of asking, encouraging, or hiring someone else to commit a crime for you. Let's say you offer a hitman $10,000 to kill your enemy. The moment you ask, you have committed the crime of solicitation. But let's assume the hitman actually goes through with it and commits the murder.
Can the prosecutor charge me with both the solicitation and the completed murder?
No. Under the modern exception, one who solicits another to commit a crime cannot be convicted of both the solicitation and the completed crime. The incomplete act of asking merges entirely into the completed act of the murder. You will be punished severely for the murder, but you will not get an extra sentence tacked on for the asking.
That makes logical sense. The asking was just a step toward the final goal. What about the crime of attempt?
Attempt follows the exact same logic. A person who completes a crime after attempting it may not be convicted of both the attempt and the completed crime. If you buy gasoline, walk up to a house, strike a match, and try to burn it down, you have committed attempted arson. If the house actually burns to the ground, you have committed arson.
So the prosecutor cannot charge me with attempted arson for striking the match, A&D arson for the fire.
Correct. The attempt merges into the completed crime. You are only convicted of the arson.
Okay, solicitation merges. Attempt merges. But what about the third incomplete crime? Listeners, I am stopping the conversation right here to highlight this. Circle this in red ink. What happens with conspiracy?
You're right to highlight it. This is the massive MBE trap. Conspiracy does not merge.
Let's define conspiracy first.
Conspiracy is an agreement between two or more people to commit a criminal act, plus some overt step taken toward that goal. It is essentially planning a crime with a partner.
So let's say my friend and I sit down and plan a bank robbery. We draw maps, we buy masks. That is the conspiracy. Then the next day, we go to the bank and we actually rob it. That is the completed bank robbery. Why can't the conspiracy merge into the robbery just like attempt did? It was just a step toward the goal.
It seems like it should merge, but the law views conspiracy entirely differently. The Supreme Court has ruled that a conspiracy to commit a crime is a completely distinct evil from the crime itself. The law believes that a group of criminals working together is inherently more dangerous to society than a lone criminal. A group can plan bigger crimes, support each other, and intimidate witnesses. Because the group danger is a separate harm from the actual robbery, conspiracy does not merge with the completed offense.
So I can be sent to prison for 5 years for robbing the bank, and another 5 years for planning to rob the bank.
Absolutely. You can be convicted of both, and you can serve consecutive sentences for both. The planning is a separate, punishable danger. Never merge conspiracy on the MBE.
That is a brutal trap.
Yeah.
Solicitation and attempt merge. Conspiracy does not. Now, does the model penal code agree with this harsh rule?
The model penal code, true to its goal of logic and fairness, takes a slightly different approach regarding multiple inchoate crimes. Under the MPC, a defendant may not be convicted for more than one inchoate crime when his conduct was designed to culminate in the commission of the same single crime.
What does that mean in practice?
Imagine a determined criminal. He solicits a friend to help him rob a bank. Then they conspire together to rob the bank. Then they walk up to the door and attempt to pick the lock, but fail. Under the strict common law, they might face multiple charges. But under the MPC, because the solicitation, the conspiracy, and the attempt were all aimed at the exact same goal, the bank robbery, the defendant only gets punished for one of those incomplete steps. They all merge together because they share a single ultimate objective.
The MTC is much more merciful. Okay, that covers Exception 1, incomplete crimes. Let's move to Exception 2. This involves the constitutional protection against double jeopardy. What is the rule here?
Exception 2 is about lesser included offenses. This is directly tied to the Fifth Amendment's prohibition against double jeopardy. You cannot be placed in jeopardy, meaning at risk of conviction twice for the same offense. You cannot be retried after an acquittal. And crucially, you cannot be convicted of both a greater offense and a lesser included offense at the same trial for the same act.
This sounds conceptually difficult. How do I know if one crime is a lesser included offense of another? What is the test?
The legal test is strict. A lesser included offense is one that consists entirely of some, but not all, of the elements of the greater crime. Every single element of the lesser crime must be required to prove the greater crime.
I think an analogy will help here. It sounds like Russian nesting dolls.
That is the perfect analogy. Imagine a large wooden doll. That is the greater crime. If you open it up, and the smaller crime fits perfectly and completely inside the larger doll, then it is a lesser included offense. The small doll brings no new elements. It is entirely swallowed by the big doll. Because it is completely inside, you cannot be punished for holding the big doll and the small doll. They merge.
Let's apply the nesting doll analogy to a real MBE fact pattern. Let's use the drug box example from the source material.
This is a classic test of the elements. A defendant is arrested carrying a box of narcotics. The prosecutor is aggressive. Based on this single act of carrying the box, the prosecutor charges her with 3 distinct crimes. Charge 1, illegal possession of narcotics. Charge 2, illegal possession of narcotics for sale. Charge 3, possession of a drug not in a properly stamped container.
Can the jury convict her of all 3 charges for holding one box?
Let's test them. First, look at Charge 1, simple possession, and Charge 2, possession for sale. Can she be convicted of both?
Let me use the doll analogy. Simple possession requires proving she knowingly held the drugs. That is the small doll. Possession for sale requires proving she knowingly held the drugs. PLUS, she had the intent to sell them. That is the big doll. The small doll fits perfectly inside the big doll. You cannot prove possession for sale without automatically proving simple possession.
Exactly right, because simple possession consists entirely of elements found within the greater crime of possession for sale. It is a lesser included offense. They merge. If the jury convicts her of possession for sale, they cannot also punish her for simple possession. She gets 1 sentence.
Okay, so the first 2 merge. What about Charge 3, the improper container charge? Can she be convicted of possession for sale and the container charge? They happen at the exact same time.
Time does not matter. We must look at the elements. Do they fit inside each other? Possession for sale requires an element that the container charge does not the intent to sell. So the container charge does not fit inside the sale charge.
But wait, does the sale charge fit inside the container charge?
No. The container charge requires an element that the sale charge does not care about the lack of a proper tax stamp on the physical box. You could be guilty of possession for sale while carrying a perfectly stamped box. The sale charge does not require an improper container.
I see. Neither doll fits inside the other. They are just 2 completely different dolls. Box A has a unique element, the intent to sell. Box B has a unique element, the missing stamp.
Precisely. Because each crime requires proof of an additional fact that the other does not, they are completely separate offenses. They are not lesser included offenses of each other. Therefore, there is no double jeopardy violation. They do not merge. She can be convicted and serve consecutive sentences for both possession for sale and the improper container, all from holding one box.
That is a brilliant breakdown. Every element must be swallowed. Let's look at another example to cement this, the joyriding example. The Supreme Court case is Brown v. Ohio. What happened there?
A teenager hotwires a car and takes it for a joyride. He is caught and convicted of operating a motor vehicle without the owner's consent. He serves his time. Later, an ambitious prosecutor looks at the exact same incident and decides to indict him again, this time for the more serious crime of theft.
Can he be prosecuted for theft after already being convicted of joyriding?
The Supreme Court said no. They looked at the elements. What does theft require? It requires taking someone's property without consent, PLUS, the specific intent to permanently deprive the owner of it, meaning you intend to steal it forever. What does joyriding require? It just requires taking the car without consent.
So joyriding is the small doll. It fits perfectly inside the big theft doll. Every element of joyriding is required to prove theft.
Exactly. Joyriding is a lesser included offense of theft. Because they are legally the same offense for double jeopardy purposes, a conviction for the lesser offense absolutely bars a subsequent prosecution for the greater offense. The government had their chance, they cannot try again.
Let's do one more example of lesser included offenses, because this is so heavily tested. The felony murder example. The case is Harris v. Oklahoma.
This is a tragic scenario. Two men decide to commit an armed robbery of a grocery store. During the chaos of the robbery, one of the accomplices panics and shoots the store clerk, killing him. The defendant who did not pull the trigger is still convicted of felony murder because the death occurred during a dangerous felony he participated in.
Okay, so he is serving time for felony murder.
Later, the state decides to charge him in a second trial for the underlying armed robbery itself based on the exact same incident. Does the robbery merge with the murder?
Let me test the elements. To prove felony murder, the prosecutor must prove that the defendant committed the underlying felony, in this case, the armed robbery. If there is no robbery, there's no felony murder. So the robbery is the small doll. It is completely swallowed by the murder charge.
Your analysis is flawless. Because the armed robbery was the necessary underlying felony for the felony murder conviction, it acts as a lesser included offense. The Supreme Court ruled that a person cannot be convicted of both felony murder and the underlying felony that supported it. They merge. The second prosecution is barred.
The nesting doll analogy works every single time. Okay, we know the rules, we know how to test the elements, but earlier you warned me about a final twist, a legislative exception to all of this logic. What is the case of Missouri v. Hunter?
This is a warning that the legislature ultimately controls the punishments. We just spent 20 minutes explaining that lesser included offenses merge to prevent double jeopardy. But the Supreme Court in Missouri v. Hunter ruled that the double jeopardy clause does not limit the legislature's power to define crimes and fix punishments.
What does that mean? Can the legislature just write a law saying double jeopardy doesn't apply?
Basically, yes. If the legislature explicitly and clearly writes a statute intending to punish you twice for the exact same act, the courts will allow it. It is called cumulative punishment.
Explain the gun example to me, because that seems to violate everything we just learned.
A defendant robs a convenience store at gunpoint. The state has a standard statute for armed robbery, which carries a 10-year sentence. But the state legislature was very angry about gun violence, so they passed a second special statute called Armed Criminal Action. This statute basically says if you use a gun while committing any other felony, you get an extra consecutive 5 years in prison. The legislature specifically drafted this law to stack on top of the robbery charge.
But wait, armed criminal action requires proving the underlying felony. It is a nesting doll. It should merge.
Under the normal Blockberger test for elements, it looks like it should merge. But the Supreme Court said that if the legislature's intent is crystal clear, if they specifically intended these to carry separate cumulative punishments, then the double jeopardy rule steps aside.
So the defendant gets 15 years, 10 for the robbery, and 5 for using the gun during the robbery.
Yes. The imposition of cumulative punishments for two statutorily defined offenses does not violate double jeopardy, if the legislature specifically authorized it. However, there is a procedural limit. The prosecutor must impose these stacked punishments at a single trial. They cannot try you for the robbery this year and try you for the gun charge next year. But if they bring both charges at once, and the legislature explicitly wanted to stack the time, they do not merge.
That is a harsh, tricky exception. The legislature can bypass the nesting doll rule if they are clear enough about wanting to punish you twice. This has been an incredibly dense section. Let's do our final massive recap. Listeners, Section 7 recap. The double jeopardy trap, or merger. Generally, under modern law, multiple crimes do not merge. But memorize the exceptions. Exception 1. Incomplete crimes. Solicitation merges into the completed crime. Attempt merges into the completed crime. But conspiracy does not merge. You can be punished for planning and doing. Exception 2. Lesser included offenses. Think of the nesting dolls. If a small crime is completely swallowed by the elements of a larger crime, they merge. Joyriding merges into theft. A drug sale merges with simple possession. But if each crime has a unique element the other lacks, they do not merge. Finally, the legislative exception. If the legislature explicitly writes a law to stack punishments, like adding extra time for using a gun, the courts will allow cumulative punishments at a single trial.
That is a masterful synthesis of an incredibly complex topic. You have navigated the traps perfectly.
We have covered a monumental amount of ground today. We started with the sheer power of the state and the strategy of the MBE. We mapped out where the federal and state governments get their jurisdiction. from national parks to the modern rules of CITES. We explored where the law is actually written, seeing the death of common law crimes, but the vital survival of common law defenses. We dove deep into the philosophy of why we lock humans in cages, discussing retribution, deterrence, and rehabilitation. We looked at the real-world horrors of moral turpitude. We armed ourselves with the Constitution, using void for vagueness and ex post facto rules to shield against tyranny. We learned how to read the fine print, applying the rule of lenity to break ties in favor of the citizen. And finally, we survived the double jeopardy trap, learning exactly when crimes merge and when they stack.
It is a massive foundation. To the listeners, you now have the playbook. You understand not just what the rules are, but why they exist. You understand the historical fears of tyranny and the modern desires for order that shaped every single statute.
Absolutely. Trust your preparation, keep your notes handy, review these concepts, and remember the broad principles when the examiners try to confuse you with tiny details. You can absolutely conquer this test.
Before we sign off, I want to leave you with one final provocative puzzle to ponder as you continue your legal studies. We discussed how modern legislatures rushed to abolish the old judge-made common law crimes and replace them with shiny new statutory codes. But we also learned that they often forgot to write down the vital common law defenses, like necessity.
Right. The ghost of the common law survives.
Exactly. But imagine a scenario that tests the limits of this system. Imagine a citizen is trapped in a horrific situation, perhaps a massive hurricane. To save the lives of their family, they are forced to break a newly written, highly specific, modern statutory crime. A crime that didn't even exist at common law, like hacking a computer system to open a floodgate. When they are brought to trial, they plead necessity. But the modern state code is entirely silent on the defense of necessity. What does the judge do? Does the judge reach back into the mists of history, invoke the ghost of a common law defense, and let a hero walk free? Or does the judge look at the strict modern separation of powers, declare that the legislature's silence is binding, and lock them in a cell because the words of mercy simply aren't on the page? It is a clash between rigid statutory interpretation and fundamental human justice. And it is exactly the kind of deep legal conflict you will spend your careers navigating.
That is a profound question. Do we serve the exact words on the page, or the spirit of justice that the words were meant to protect? A massive thank you to our listeners for joining us on this deep dive. Keep studying, stay focused, trust your foundation, and we will see you next time.